Thank you for joining us tonight for the Northwest Consumer Law Center webinar series. Tonight's webinar is Bankruptcy 101. We'll be covering the basics about the process and addressing some of the most frequently asked questions for those thinking about filing for bankruptcy. My name is Amanda Martin, and I'm the Executive Director at the Northwest Consumer Law Center. We are a nonprofit organization, and our mission is to advance economic justice. If you have questions during the presentation, please enter those in the chat box on your right. We will be answering questions at the end of the presentation. This session is being recorded and will be available to view on our website in a few days. And attending this webinar does not create an attorney-client relationship. If you are seeking legal advice, we recommend that you contact Northwest Consumer Law Center after this webinar, as this session is only going to provide legal information. It's not a substitute for individualized legal advice. Information on how to apply for our services will be posted at the end of this presentation. And with that, let's go ahead and get started. So let's start with our basic definition of what is bankruptcy. Bankruptcy is a process which allows individuals and businesses to get out from under debt with the protection of the federal bankruptcy court. It is an opportunity to get a financial fresh start. Generally, bankruptcies fall in two types: liquidation and reorganization. Now, at Northwest Consumer Law Center, we help low and moderate income individuals with bankruptcy. So most of the communities that we serve are choosing between either Chapter 7, which is a liquidation bankruptcy, or Chapter 13, which is a reorganization or also a repayment plan. And we're going to talk a little bit more about the differences between Chapter 7 and Chapter 13 in a few minutes. Tonight, you're going to hear the word debtor used often. Debtor is the person who is filing for bankruptcy. So now that we have those basic definitions, let's talk a little bit more before we get further about the stigma of bankruptcy. Now, I've met hundreds of folks during my career who are thinking about filing bankruptcy, and they have expressed a lot of anxiety and shame and embarrassment around their situation. Now, I've helped folks from all different walks of life, and what I've learned is that the majority of Americans, the majority of us, no matter how financially savvy we are one major crisis away from bankruptcy. People get hurt in accidents, people get divorced, people unexpectedly get laid off. Life happens, and that's why bankruptcy is here. It's here for a reason, to help people get a fresh start when the unexpected happens. Bankruptcy can be a powerful tool to regain control of your financial situation and earn that fresh start. And I like to tell my clients about the famous people who have filed for bankruptcy and use that fresh start as a springboard for their later success. So we have President Lincoln, who filed bankruptcy at a young age and then started his political career. Walt Disney also filed at a young age and later went on to create Mickey Mouse. And we have Dave Ramsey, who actually filed after he built a $4 million real estate portfolio that hit some hard times. And then he became the financial counselor he's known to be. George Foreman filed after winning a heavyweight title and then went on to win another one. And then Elton John had many successful albums when he fell on financial hard times. He filed and then went on to produce more successful albums. So it's very possible to use bankruptcy as that financial fresh start and use it as the first step to your future success. Now that we talked about that, let's talk about considerations for filing for bankruptcy. Now, there are many different factors that go into whether you are eligible for bankruptcy and whether bankruptcy is the best option for you. And we could spend hours talking about all those different factors. So this is not an exhaustive list. And if you're thinking about filing for bankruptcy, you should get some individualized legal advice based on your situation from an experienced bankruptcy attorney. But what we have on here are the main considerations that most people think about when filing for bankruptcy. The number one thing we talk about first is what solutions are available outside of bankruptcy. Bankruptcy, it usually comes as one of the last options that I recommend. First, we look at is debt negotiation, settlement, or consolidation an option? Would you be able to repay the debt that you owe over a reasonable amount of time based off what your current income is? Now, there are a lot of scams out there with debt consolidation, debt settlement, people who make grand promises. Really watch out for those scams. Make sure you do your research on any type of debt consolidation, settlement negotiation type company, because again, a lot of scams out there. If you're looking for referrals for reputable places, feel free to reach out to us. Another reason a lot of people look into filing bankruptcy is if they're facing foreclosure. And what I like to recommend first is that they look at loss mitigation options with their mortgage. So if that's the only reason they need to file, they're behind on their mortgage, let's think about a loan modification first, or maybe a refinance. Another reason people come to us to file bankruptcy is if they're being hounded by debt collectors. If they're facing abusive or harassing conduct by debt collectors, they might think bankruptcy is the option to just stop the phone calls. And in some of those situations, that abusive and harassing conduct can be a violation of the Fair Debt Collection Practices Act. If you're getting contacted by third parties, there are certain obligations under the Fair Debt Collection Practices Act that they have to follow. And if they're not doing that, you may have claims against those debt collectors. So if you feel that the debt collector is engaging in unfair behavior or, again, being abusive or harassing, you should definitely talk with an attorney who's experienced in the FDCPA. And then finally, another solution is if a client is collection proof. And what collection proof means is that your income and your assets are protected from debt collectors. So even though a debt collector could sue you on a debt, they have no way to force you to pay. Your income, for example, would be Social Security. They cannot garnish your Social Security, or you don't have any assets like a house they could put a lien on. Those are situations where people would be collection proof, and bankruptcy might not be the best solution for them because the creditors have no way to force them to pay them back. Another consideration is whether someone's facing an urgent legal situation, like an impending foreclosure, a garnishment, a repossession. Those can be situations where somebody files for bankruptcy to get the protection of the automatic stay. This is the pause button, which would pause that foreclosure or garnishment or repossession, and then using the bankruptcy to either get the discharge of their other debts or do a reorganization. Another consideration that we think about, especially right now, is how long is your financial hardship expected to last? This is really people who are on unemployment. Some people get unemployed and want to file bankruptcy right away. That might not be the best solution for everyone, depending on how long unemployment is expected to last. If you have another job lined up, and then repaying the debt might be a good idea, a good solution at that point. So it's all a consideration. Obviously, no one knows what the future is going to hold, but something to think about of, what is that future going to look like, and is another solution going to be available at that point? Finally, if you file for Chapter 7, will you be able to keep all of your property in bankruptcy? Is all your property going to be exempted, protected? We have some situations where people are thinking about filing for bankruptcy, and maybe their home wouldn't be protected if they filed. So then it becomes a balancing act of, is staying in the house feasible, or is getting this discharge of the debt? And that really comes up to the individual to decide, what's in their best financial interest and what's just in their best interest overall. And then finally, if someone chooses to file bankruptcy, decides that it's the best decision for them, when is the ideal time to file? We talked a little bit ago about people who are unemployed. We usually recommend people wait till the end of their unemployment period to file for bankruptcy. Usually just during that time, they don't have the funds to pay unexpected medical bills that might come up. So thinking about the timing of the filing is also very important. Once somebody decides, okay, I'm going to file for bankruptcy, then again, most individuals choose between Chapter 7, which is the liquidation, and Chapter 13, which is our reorganization. A Chapter 7 is the liquidation, which makes it sound a lot scarier than it actually is. Most people are able to keep all of their property when they file for Chapter 7, but again, you should always speak with an attorney first to ensure that. The goal of a Chapter 7 is to get a discharge, that fresh financial start. Chapter 7 typically lasts between 3 and 4 months. A trustee can sell non-exempt assets. So the trustee is the person who is appointed by the court to oversee the bankruptcy case and sell any property that isn't protected by the law. So that's a consideration for filing Chapter 7. If you have that property that's not going to be protected, you should know that before going into Chapter 7. You could only receive a Chapter 7 discharge every 8 years. There's no such thing as a hardship discharge in Chapter 7. It's 8 years from the date of the last filing. And finally, you have to pass what's called the means test. So you can file a Chapter 7 if you are below the state median income level for your household size. And if you're above that, there's a means test you can go through to see whether you're eligible for Chapter 7. Simply put, if you make too much money, Chapter 7 won't be an option for you. At Northwest Consumer Law Center, we help low and moderate income folks. Everyone who comes to us for services is eligible for Chapter 7, at least income-wise. Now let's talk about Chapter 13. This can be an option if you are a above median income debtor, but it can also be an option if you're a below median income debtor. And you might be thinking, why do you choose to file Chapter 13 if you're eligible for Chapter 7 under your income? And that's typically because there's a repayment plan that needs to be implemented. Chapter 13 is a great way to force your creditors into a repayment plan. And a lot of the people we help are either dealing with a mortgage arrearage, they're behind on their mortgage, they force their mortgage company into a payment plan in the Chapter 13. If they have traffic tickets that are holding up their license, if they have a car payment they're behind on, maybe they're behind on taxes that aren't dischargeable in Chapter 7 in some situations. A Chapter 13 can be a great way to force those creditors into a repayment plan. A good thing about Chapter 13 is that that payment plan is, as long as you are following the bankruptcy code, what is allowed for in that code, the creditor basically has to accept that force plan. In a Chapter 13, you're required to commit your disposable income to the plan. So when you take your income, what you bring home, your net income every month, and minus your normal monthly expenses, whatever is left over has to go to your Chapter 13 plan. So that means if you get this great raise, you're going to have to pay more towards your creditors. Chapter 13 typically lasts between 3 to 5 years. If you are a below median income debtor, you can choose anywhere at least 3 years, a maximum of 5. If you're above median income debtor, your plan is probably going to be 5 years. So once you decided between Chapter 7 and Chapter 13, then let's talk about the bankruptcy process. The first step is preparing your petition and schedules. Your petition and schedules is a list of all of your debts and all of your assets. They are that 60-page bankruptcy form packet that's on the bankruptcy court website. You got to fill all of those out. You also have to take a credit counseling course. The court has approved dozens of credit counseling courses for pre-bankruptcy counseling. You can do that counseling online or by phone. You can do it anytime, 24/7. And there's a list of the approved agencies on the bankruptcy court website. You also have to pay a filing fee if you're filing for bankruptcy. For Chapter 7, it's $338. For Chapter 13, it's $310. If you don't have that filing fee up front, you can either ask the court to pay it in installments over a couple months, or if you're below 200% of the federal poverty level, you can ask the court for a waiver of that filing fee. So once you got your petition and schedules ready, you have your credit counseling course done, and you have that filing fee or the waiver of the application ready, you are ready to file your petition and schedules with the court. And right now, because of COVID, since the courthouse is closed, you can either mail in your documents to the court, or you can actually upload them online for filing. And we'll give you the link to all that information at the end. Once you file bankruptcy, the automatic stay goes into effect. The automatic stay is a very powerful tool in bankruptcy. It is a pause button. It prevents your creditors from attempting to collect from you. And has a very broad effect. It applies to phone calls and letters and other communications. It puts a stop on garnishment, a stop on a foreclosure sale, a stop on a repossession that's about to happen. Again, very powerful, very broad effect. It does not go into effect until that case is filed with the court. So once it's stamped by the court, you have a case number, that's when that automatic stay goes into effect. The automatic stay can be limited in some situations. If you have previous bankruptcy filings, it could be limited to 30 days or not go into effect at all. So if you are someone who has filed bankruptcy in the past year and you're looking to file another bankruptcy, you should definitely get advice from an attorney. It doesn't automatically go into effect for some situations, or sometimes it's limited. So definitely, if you have those multiple filings, get some good legal advice on that. There are some situations where it can be extended, but you have to file a motion pretty quickly. So just be aware of that. The automatic stay does not apply to criminal proceedings. It also doesn't apply to family law proceedings, except when there's a division of assets. So in a divorce, if a property is being split up, the automatic stay does apply to that, but otherwise it doesn't apply to other family law proceedings. So that automatic stay goes into effect. Your case is filed. What happens after that? Your court date is assigned. This is called the 341 meeting of creditors. And you also get a trustee assigned. The trustee is the person appointed by the court to administer your bankruptcy case. And you have to send certain documents to that bankruptcy trustee after your case is filed. And those are called 4002 documents. That's the section of the bankruptcy code that requires these documents. And these are things like your tax return, your bank statements, pay stubs. Those all get sent to the trustee to review and make sure they match up with the information you put on your petition and schedules. Finally, that's when your court date comes, the 341 meeting of creditors. The 341 meeting of creditors is held by the bankruptcy trustee. And it's a time for creditors to show up and ask you questions. It's kind of misnamed because creditors very rarely show up. The real main purpose of it is really just for the trustee to get you on record saying, yes, I did list all my debts, I did list all my assets, the information on my bankruptcy documents is accurate. They verify your identity, and then they also can ask questions about any property that might not be exempt, might not be protected in the bankruptcy. And again, if there are creditors who show up, they can ask you questions about your financial situation, but it's very rare that creditors show up. These days, our 341 meetings are all being held telephonically, which is fantastic. If you are at a 341 meeting, there will be about 10 other people who have filed bankruptcy, along with their attorneys if they have one. Trustee asks a list of questions, again, mostly just getting you on record, verifying that all of this information is true and correct. After your 341 meeting, you take a financial management course. This is very similar to the credit counseling course. You do it online or by phone. There's a list of the court-approved agencies on their website. And then once that financial management course is done, you file it. About 60 days after your 341 meeting, that is when that discharge is granted. So the whole process from start to finish is about 3 to 4 months. Now let's talk more about that bankruptcy discharge. That is the goal in most bankruptcy cases. And a discharge is a very powerful tool because it gets rid of your personal liability for your dischargeable debt. Now, generally, dischargeable debt includes credit card, medical debt, personal loans, car loans, and mortgages. You can actually get rid of your personal liability for it on bankruptcy. If you want to keep the property, keep the car, keep the house, you got to keep making your mortgage payments, keep making your car payments, but you don't have any more personal liability. It's only attached to the property now. Generally non-dischargeable is student loans, domestic support obligations, criminal fines and restitution, and personal injury claims related to intoxicated driving. Again, I say generally for both dischargeable and non-dischargeable debt because there's always some exceptions on both sides. For example, if there is like a fraudulent credit card charge, that might not be dischargeable in bankruptcy. So if you're wondering whether something's dischargeable or not, you should definitely talk to an attorney about it. Another important thing about bankruptcy, and we talked about this a lot already, are assets and exemptions. So assets are your property, your real property, so your houses, lands, and your personal property, which are things you think like vehicles, household goods, jewelry. Some assets that people don't always think about are inheritances, retirement accounts, stocks. If you have a claim against someone, for example, let's say you're involved in a car accident and you haven't talked, and there was an injury and you haven't talked to an attorney about it yet, that's still an asset. It's a claim that needs to be listed on your bankruptcy petition and schedules. You're required to list all of your assets when you file for bankruptcy. What goes with assets but exemptions? Exemptions are, simply put, the laws that allow you to keep certain property when you file for bankruptcy. They allow you to keep certain types of property up to certain dollar amounts. So for example, under federal law, retirement accounts are fully exempt, 100%, doesn't matter the amount. Other things like vehicles under federal law are exemptable up to, it's like about $3,800 these days. The amounts change every year. In Washington state, we have federal exemptions and we have state exemptions. The main difference between our federal and our Washington state exemptions is that the state exemptions allow you to protect a lot more equity in your home, which is actually going up very soon, significantly. Currently, today, it's $125,000. In a couple weeks, it's going to increase dramatically to the per county median home price. The federal homestead exemption is around $22,000, so that's a big difference. If you own a home, you're probably picking state exemptions. If you don't own a home, you're probably choosing federal exemptions, because the federal exemption has a wild card, which you can use on any type of property up to about $13,000. The state exemptions don't have that high of a wild card. Exemptions can be very tricky. This is where most people get tripped up on their schedules, where most people run into issues by just not listing things properly or not listing their exemptions correctly. So you should definitely talk to a bankruptcy attorney so you make sure you have your exemptions correct. If you don't list your property, or if you don't list your exemptions, you can actually lose your rights to the property. So this is a very important thing to consider when thinking about bankruptcy. Now let's talk a little bit more about debt, secured versus unsecured debt. So unsecured debt is debt where there's no security interest. You only have personal liability. So if you don't pay it, they can only go after you, like credit cards, medical debt. Secured debt, if you don't pay it, they could go after you, your money, or they could go after the item, such as a mortgage. If you don't pay it, they can take away the house. The car loan is a secured debt. If you don't pay it, they can go after the car. In bankruptcy, you have some interesting options for secured debt. The first one is surrender, which is as it sounds. If you can no longer afford the car loan and you decide, you know what, I want to get rid of this, you can surrender it, get rid of that personal liability for that debt. You can also redeem the vehicle in a Chapter 7. You can pay the fair market value of what the car is in order to discharge the remainder of the liability. So if you're underwater on your car, you could redeem it and you could get a much better deal. A lot of people that we help aren't in the situation where they have that cash to come up with right away during their bankruptcy, but it is an option in Chapter 7. Another option is to retain and continue making payments. This is what most people do on their mortgages in bankruptcy. If they are able to keep the house, they're current on their payments, they can discharge their personal liability, but they can keep the house as long as they continue making their payments. If they don't make their payments, then a foreclosure proceeding can begin. And then the last option on here is to reaffirm. So this essentially takes the debt out of the bankruptcy. You are reaffirming your personal liability on the secured debt. Reaffirmation agreements in some situations can be favorable. Sometimes they'll lower the interest rate, they'll give you a better payment. But if you're considering reaffirming, you're essentially taking it out of the bankruptcy. You should really get some advice on that because that debt is no longer dischargeable. For example, if you have a car, you're current on those payments, reaffirming it, if something happens in the future, you're not able to make that car loan on it, you're still going to have that personal liability if you reaffirm. So there's some consequences there. Sometimes there's benefits. Really, talk to an attorney to see whether that's going to be in your best situation for you. Let's talk about some do's and don'ts for filing bankruptcy. Some major don'ts that we see are paying back family members that you owe money to. We advise all of our clients that if you owe your family members money, don't pay them back before filing for bankruptcy. The reason for that is that if you pay family members back over, let's say, Chase Bank or your medical bills, it's considered a preference. You're preferring one creditor, a family member, over another, Chase Bank, which practically makes sense. But the bankruptcy code provides that the bankruptcy trustee can actually go after that money that you paid back to your family member. Now, if you paid a family member back $20 that you owed, is it likely the trustee is going to go after that? Probably not. But if you paid them a couple thousand, they might go after that money, and they would go after your family member, and the bankruptcy code allows them to do that. So be very careful. We generally advise don't pay back family members before filing for bankruptcy. Another don't is hiding or giving away or failing to disclose assets. Some horror stories we've seen are people who gave vehicles to their children to try and hide them or not disclose them to the bankruptcy court. You have to list all of your assets when you file for bankruptcy. You can't transfer things, especially to family members, before filing bankruptcy to try and hide them away. Another thing we get asked a lot about is whether you can use credit cards to pay non-dischargeable debt. For example, can you pay your credit card or your student loans with credit cards and then discharge that in bankruptcy? The answer is no. The bankruptcy court has held that as fraudulent because you're converting that non-dischargeable debt into dischargeable debt. So don't use your credit cards to pay anything that wouldn't be dischargeable. It's not a way to get around that system. Some dues, we, as I've said many times during this presentation, recommend to get legal advice from an experienced bankruptcy attorney. For many people are able to do bankruptcy on their own. I recommend everyone get advice from an attorney to make sure that you know exactly what you're getting into, that you know the risks that are involved before you file for bankruptcy. You must disclose all of your assets, your debts, and certain financial transactions that they ask about as required by the bankruptcy code. The way most people get in trouble in bankruptcy is if they don't disclose something. Like I said before, if you don't disclose your assets, you're not going to be able to keep them when you file for bankruptcy. There is case law out there saying that you can waive your right to those exemptions. So just make sure full disclosure when you're filing for bankruptcy. And finally, keep track and comply with all the court deadlines. If you're filing for bankruptcy on your own, it can be pretty confusing. So make sure, again, talk with an attorney, figure out what those deadlines are going to be. For example, turning over those 4002 documents, those documents that go to the trustee before your court date, showing up at your court date. You have to comply with all of these steps in order to get your discharge. So just make sure you keep track of those and that you comply with them. Let's talk about some resources available for people who are filing for bankruptcy. Northwest Consumer Law Center, we hold the Pro Se Bankruptcy Clinic. It's on the first and third Thursday of each month from 2 p.m. to 4 p.m. And right now, due to COVID, we're holding that clinic over the phone. We have 20-minute phone appointments. You can schedule your appointment in advance online, or you can call our intake line to schedule an appointment. We regularly have openings every first and third Thursday. So if you're interested, go ahead and sign up. Once things get back to the new normal, we'll be holding that clinic again in person. The clinic is a great chance to have somebody just give you advice on the options for filing, tell you about the risk. We look over people's paperwork to make sure there's no red flags, that everything's filled out completely. We walk people through what documents to send to the trustee, what their discharge means. It's a really great tool for people who are looking to file bankruptcy but can't afford an attorney. This clinic is for people under 200% at the federal poverty level. Those guidelines are available online on our website, and the clinic is brief advice only. So again, we would love to look over your paperwork, make sure it's accurate, give you advice, but we don't fill the paperwork out for you, and we don't show up to court with you. It's just brief advice during that clinic only. People can attend the clinic as many times as they need to during the course of their case to make sure they're on track. I also recommend the Western District of Washington. That's in Seattle bankruptcy website. The link's available on the screen. There are many resources available under filing without an attorney. That is where all the court forms are. They also just have a lot of great information and disclosures about bankruptcy. They have some great videos on there as well, where you can learn more about bankruptcy. And with that, I'm going to go ahead and open it up for questions. If you have any questions, go ahead and enter those in the chat box on your right, and we'll go ahead and get started. So one of the questions was, where can I get the bankruptcy forms? Those are available, again, on the bankruptcy court website. It's wawb.uscourts.gov, and those are all available on there to print. And then our next question is about discharging student loans in bankruptcy. So generally, student loans are not dischargeable in bankruptcy. If you just file the forms, you go through the process, your student loans will not get discharged. There's a special proceeding. It's called an adversary proceeding. It's like a lawsuit within bankruptcy that you have to file if you want to discharge your student loans. And in Washington State, we're in the Ninth Circuit, and that follows the undue hardship test. And this is a test that involves many different factors. It looks at your past income, what your current income is, your future income, expenses. It looks at a lot of different factors of your student loans, and it basically determines if they're going to be placed in undue hardship as determined by the case law, how that's defined, if you have these student loans in the future. And we've actually seen some pretty positive trends of courts maybe not discharging the entirety of the student loans, but discharging a good portion of that. It is a pretty complicated process. I've been saying this a lot, but if that's something that you think you might qualify for, definitely talk to an attorney about it, because again, it's just a whole separate proceeding within your bankruptcy. All right, and I don't see that I have any other questions. Go ahead and join us for the next session in our NWCLC webinar series that's going to take place on May 12th at 6 p.m. We hold these webinars every month, usually on the second Wednesday. This one was on the third Wednesday of the month at 6 p.m. Our next session is going to be a foreclosure 101. We're going to talk all about the non-judicial and judicial foreclosure process in Washington State, how you can take advantage of the protections provided by the Foreclosure Fairness Act and all the different options to avoid foreclosure. You can sign up for that webinar series on our website at nwclc.org. There's also other sessions in our webinar series about bankruptcy, foreclosure, student loans, debt collection, all available to view on our website at any time. If you're seeking legal representation, you're welcome to reach out to us. We help people up to 500% of the federal poverty level. Those income guidelines are all on our website. We help people with, again, bankruptcy, student loans, automobile fraud, debt collection, defense. And you can apply for help at any time on our website, nwclc.org, apply-for-help, or by phone at 206-805-1722. And we have a lot of other great information. Our website just got updated, so I urge you to check it out. Thank you so much for joining us tonight, and take care.